we've got Jones Stutsman, file 23-6718 FH sentencing. We also have a pending contempt matter, but that matter hasn't been resolved in Chippewa County, has it?
Not to my knowledge.
Okay, I think it's probably best if we dismiss that contempt and defer to Chippewa County.
I thought she pled no contest.
She pled no contest.
Yeah.
To the violation?
Yeah, at the time of the plea.
Oh, okay. All right. Oh, she did. I see that. Okay. All right. All right, Mr. Gilbert, have you had a chance to review the report and recommendations?
Yes, we have gone through the report and the recommendations, and there are no additions or corrections.
And the advisory guidelines are 0 to 6. Any scoring challenges?
No scoring challenges, Your Honor.
Ms. Goodrich, any additions, corrections, or scoring challenges?
No, Your Honor.
All right, Mr. Gilbert, go ahead.
One of the major things that I know my client would like to get from today is she can start after the sentencing to have contact with her mother. This has been her mother is involved in this case. I know this has been something from the beginning that's been very painful for her. Considering the low concern my client has had until this point in her life, no issues whatsoever, no misdemeanors, no felonies. I'd ask the court to take that in consideration. We believe the period of probation is appropriate, and we'd ask that the court sentence her to time served and the rest of the recommendations as prescribed in the PSI.
All right, thank you. Ms. Stutsman, you don't have to tell me anything today, but it's allowed. Is there anything that you want to tell me? Or no?
Not that I'm aware of.
Thank you. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor. I'm in agreement with the recommendations in the PSI. The defendant is 67 years old with no prior criminal history. At the time that she was appointed full conservator, she was using her mother's money for her own purposes, and while having her mom pay for the defendant's apartment, her own mother was living in a house that had a leaky roof, that had no running water except for in the kitchen sink. Her mom was suffering from dementia and didn't have anybody overseeing whether she was taking her medicine or taking care of herself or eating or having proper food and provisions in the home. It was such horrible conditions that the newly appointed conservator never took her back to that home once she was court appointed, and took her to a home where now she's being properly taken care of and in a memory unit, receiving proper care. Even despite this case pending and everything that happened, the newly appointed conservator was constantly asked by the defendant for additional monies of her mother, and just didn't seem to understand that that was not an option. And so on page 2 of the CFJ 284, where it talks about the self-report criminal thinking scale, that she really can't rationalize her criminal behavior, I thought that that was appropriate working on this case, that she just doesn't understand the error of her conduct, which is concerning. Ask the court to take all that into consideration.
All right, thank you. All right, Ms. Stutsman, well, you're 67 years old. You have no prior record, but this is a case that the more I learned about it, the more I was troubled by your conduct. That you not only violated the trust,
I'm not told anything about any difference what I was supposed to do or act with the trust. So I just kept doing what we were doing. That's the way my mom and I's always lived. While I was in Petoskey, she always paid my rent. She's always helped me with this, that, and the other thing. So I just kept doing what we were doing.
well, you pled guilty.
Just to get it over with. I was
You want to withdraw
innocent.
your plea? I'll let you withdraw your plea and we'll set it for trial.
He said I wouldn't win, so
Well, it's not up to him. He advises you.
whatever to get out. That's all I want. I want to go home and
Yes.
see my mom.
All right, you've pled guilty. That's part of the problem is you
We were close.
pled guilty, but think you didn't do anything wrong, but you did. You violated the trust of your mom. You violated the trust of the probate court that appointed you a conservator, all to kind of help out your son who's in prison, stealing from your elderly mom to help out your son in prison. And then while you're on bond, you're smuggling drugs into a prison, again, for your son and for your own financial benefit. That's really pretty troubling conduct. And And you completely think that we're all wrong about that. Well, I'm telling you, we're not wrong. You take a poll of people in the community. Should you take money from your mom and give it to your son in prison? Should you smuggle drugs into prison? I guarantee you about 100% of people are going to say, no, you shouldn't do those things. You did those things, Ms. Stutsman. And so I gave you an opportunity to speak. So now is the time for the sentence to be imposed. I don't think, so obviously there's restitution that's ordered, agreed upon at $55,371. There's a crime victims assessment of $130. You have to comply with DNA testing and pay a $60 fee, and there's $68 in state costs. I'm not going to assess court costs. I don't think you're going to pay a penny of that.
I will.
Yeah, I don't know. I don't think you will. And I certainly don't think that placing you on probation accomplishes anything. She's got no understanding of her criminal behavior, and she's on Social Security disability. I mean, probation to help oversee payment of $55,000 is not going to accomplish a thing.
Can I just have it automatically taken out of my account?
Ms. Stutsman, I gave you a chance to talk.
I didn't know we were going this direction.
We're done with it.
I gotta respond to what I hear.
We're done with that. So, given the issues on bond and the sheer amount embezzled, I think even though it's 0 to 6 calls for no incarceration, I do think there is reasonable grounds for incarceration. So I'm not going to place you on probation. I'm going to order you serve 6 months in the Sheboygan County Jail with a credit for 78 days previously served. On the contempt, I'm going to order you serve 77 days, credit for 77. That's the sentence of the court. If you wish to appeal, you can file an application to the Court of Appeals. If you want a lawyer, let me know. I'll appoint one for you, but you got to ask within 42 days. There's, now that you're sentenced, there's not any limitation on your contact, but they'll have to be through phone visits or whatever from the jail. All right, that's the sentence of the court. 15-5011FH. And you're the arraignment attorney for Mr. Farrow today?
Yes, Your Honor. I have had an opportunity to review with Mr. Farrow the motion affidavit and bench warrant.
You can sit down, Mr. Farrow. That's fine.
And we did review it. We would waive the reading, and Mr. Farrow would stand witness to the allegations.
All right, so Mr. Farrow, it is alleged that you are in violation of your probation from a warrant dated July 21st of 2016. You're on probation to this court for attempted felon in possession of firearm. That would be a 2.5-year felony, I believe. Attempted felonious assault, that would be a 2-year high court misdemeanor, and felonious assault, that would be a 4-year felony. It's alleged that back in 2016, you failed to report a change of residence and your whereabouts were unknown. Also that back in 2016, you failed to immediately report police contact. Also that you failed to engage in substance abuse treatment programming, that you made a false report to your probation officer that you had enrolled in such treatment, and that you failed to address your court-ordered financial obligations. So essentially, you've absconded supervision and for near on or exceeding 8 years. So you have the right to have a hearing on those allegations where they would need to be proven by a preponderance of the evidence. You have the right to present evidence in your own defense at that hearing and cross-examine the witnesses presented against you. And you have the right to the assistance of a lawyer at such hearing. If you are found to be in violation or admit to it, I could revoke your probation and sentence you on the underlying offense to the maximum penalties that I outlined.
Your Honor, if I could, I would like the motion just for the
Your Honor, I would,
fill out and time served for this violation is what happened. That case.
Your Honor, I would advise Mr. Farrow to not make any more comments.
Yeah,
I would like to
Because,
leave him, Your Honor, because I would like to just represent myself. I informed him down there, just full disclosure
Well,
for yourself and
hang on.
prosecutor.
Hang on, before you are allowed to represent yourself, I've got to go through a pretty long process that the courts require. So you're saying that you want to waive the right to counsel and represent yourself in the matter?
For now, Your Honor, I just would like
For
to
now,
have full
what do you mean?
disclosure
What do you mean for now?
is what happened in 2014.
Hold on, no, I haven't, no, hang on.
Okay.
You want to waive your right to counsel for now? What do you mean? That you
I
just-
would just like to explain what
Okay,
the
so you don't
charges
want to
are.
waive your right to counsel. You just want to tell me something.
I would just like to resolve it today, this moment, if we could. just waive all,
There's no way I'm gonna do that, Mr. Farrow, and let me tell you why. I took the bench in December of 2018,
okay,
right? This is a 2015 case and a 2016 warrant. How much do you think I know about your case? Not a darn thing.
okay.
It would be irresponsible for me to like resolve your case today, right? I gotta learn a lot about what's going on. And-
Your Honor, could I move?
And somebody who absconds felony probation for 8 years and then finally shows up and
I was
says,
at the
I
house
want to
and
take care of this today with time served. How much weight
That
you
was
think
what
that carries?
happened, Your Honor. I called. They told me.
Mr. Farrow, hang on.
I was at the
I'm not
house.
gonna hear your
That's where they
explanation
got
right
me.
now.
I was at the
Stop
house.
talking. Stop talking. We're gonna assign it to the Office of Assigned Counsel for appointment, and we're gonna set it for a hearing.
Can we move for a PR bond, Your Honor, so I can
Yeah,
go?
you can
fight
move for that,
counsel.
and that motion is denied. You've absconded 8 years.
Okay.
Your Honor, if I
I just
may,
want to go back to the house where I got arrested, where I've been the whole time. And this is over my wife pretty much committing adultery.
Your Honor, I would just like to indicate regarding bond, Mr. Farrow has been at this location. It's not the address that we have on file for him. His address would be the 7575 Lansing Road in Perry, Michigan. It is the house where he's grown up, and he was there this entire time, Your Honor.
When they first let me out of jail, when I signed the plea bargain, I went down there and was seeing a probation officer in Shiawassee County. That's where I asked to have it transferred back. I
Your
called.
Honor, I would
Do
ask,
you know,
5
do
days
you
in a
know
row.
who it's gonna be assigned to, Mr. Virgo?
I don't, Your Honor. I let them handle that process how they do.
All right.
But I've been there the
Well,
whole time.
I'm
I
gonna-
called the probation officer. I've remained free. I haven't committed any crimes. It's an insult to sit in front of a probation officer and have him Lord God over me, over, you know.
Well,
my
that
wife
might be
committing
insulting, but it
adultery.
was ordered by a court and you ignored that order. So we're gonna set it for a probation violation hearing on June 11th at 10:50 a.m. We'll refer to the Office of Assigned Counsel for appointment, and Mr. Farrow will be held without bond. All right, we'll see you then.
And then there's no way I can appeal this to a federal court, another jurisdiction.
You can file an appeal. It'd be to the Michigan Court of Appeals. Go ahead.
Can we file that today? I mean, this is corruption. This is what I told them when I was arrested, that you guys are all Satanists, kid rape. And my wife was also a Satanist.
Our next
We'll
case
prove
is
it by
People v.
one
Scott Plumley.
Inspection of the children.
Get him out of
My
here.
wife is